Notices, again, are not anything to do with licensable HMOs. They are covered by the HMO management regulations, and those apply to all HMOs regardless of their licensing status. So any property with 3 or more people who are not a single family, who are sharing basic communities, is an HMO, regardless of whether or not it's a license. All HMOs are required by law to have a statement of the tenant's conditions of residing in the property. So a tenancy agreement, classically, has to be given to the tenant. They must have one. It's an offence if you don't. And you must have posted in the property the contact details of the person managing the property, which will either be the landlord themselves or an agent who collects the rent on their behalf. They must have their name, address and contact information posted in the property all the time. Failure to do either of those things is a prosecutable offence, and it's an unlimited fine, although usually the fine's a bit more limited, a bit more restrictive than that, or in fact you can have a civil penalty of up to £30,000 served on you. It is always worth making sure that you have such a notice, that it's not just some random bit of paper that can get torn down, so something laminated or behind a piece of plastic, and that you record its existence on the inventory as well, so that there is some independent evidence that it actually was there. Because in practice I tend to find that tenants take them down, not out of maliciousness often, but sometimes because they need to write a phone number down and it happens to be the most convenient piece of paper to keep paper going, and then a local authority might do an inspection and say it's not there. And it's not really something you can argue around or get an excuse around. The paper's either there or it isn't. It's not a matter for much dispute.